It's time for another in our Legally Speaking series with Belinda Lewis, Director at STBB, the big small firm. And Belinda simplifies in uncluttered layman's terms important legal principles associated with property law. Today we talk about a very interesting topic, and one I'm sure that will resonate with our listeners, and that's life rights. Belinda, good morning. What is a life right?
Good morning, Mark. Nice to see you, and hello to your listeners. A life right. Well, the term is not a legal definition. It is a common description used out there in the property industry for what is a contract between usually a developer and a person who is seeking retirement accommodation. The right purchased is not in the usual sense of purchasing property at all, as it is not ownership that's acquired, and being strictly governed by retired persons legislation. And for retired persons and their protection and interests, there are strict rules as to how old the occupier of a property held by life right can be.
So let's expand a little bit on that. You have to then be of a certain age to occupy these life right units. Is that right, Belinda?
Quite right, Mark. So the occupant actually residing in the property must be a minimum age of 50 years old, according to what is the Housing Development Schemes for Retired Persons Act. And there is provision for co-occupants like a spouse or a life partner who can be under 50. One must note as well that the owner or holder of the life right can even be a juristic person like a trust, which then specifically allocates the right to occupy to a beneficiary. Now, about this minimum age of 50, a developer can actually, in its own scheme, make the minimum occupant age older than 50 as they deem fit, which we've seen recently and one that we're working on, for instance, 60 or 65, entirely up to them.
To fit in with their scheme.
Quite right.
So how is life right different to ownership at the very essence?
So, Mark, on the surface it looks the same as ownership, but in its legal structure and comparing rights that flow from each of them, it is very different. If you own the property, you may sell it, renovate it, bond it, destroy it for that matter.
If you want to.
If you want to, and certainly you may bequeath it to your heirs. The property itself is an asset in your estate. And ownership is the strongest of property rights there is. With life right, if one only owns a life right, owns used loosely here in regard to the property which you're occupying, you actually and only hold a right that you've acquired, and you or your nominated occupant have the right to occupy and use the particular property. Very notably, the right lapses on the death of the life right holder occupant or co-occupant as nominated by the life right holder. It could also be terminated by agreement reached with the life right developer earlier, and it is generally the developer's prerogative to resell any such right to a new purchaser and to control that whole process. You can't try and sell it yourself if you want to get out of the life right. Next thing, with life right, the developer is paid the full consideration up front, and effectively you are paid by the developer monies later on upon the termination of the life right and according to a certain formula agreed to up front. So as such, Mark, the purchase consideration is considered to be for the duration of the life right a loan to the developer. Lastly, and quite notably with life right, what you pay up front at the beginning will dictate very much how much you will get back in the end from the investment made. The less paid up front, the more paid to you at the end, and the other way around.
And you said earlier that you cannot sell your life right. Is that right?
That's correct. It's personal to you and not something that you can alienate or dispose of to another. In a sense, the nature of a life right reminds one of a personal servitude of usufruct, which we addressed in our last Legally Speaking session. The difference to that of a usufruct is that a life right holds more value as it is considered an asset in your estate when you pass away. and for which your estate will ultimately be paid the proceeds according to the formula agreed to up front. Usually, either what you paid for it originally, or a percentage thereof, such as 80 or 90%, and even in some cases a share of the capital appreciation on resale. Or one is paid on termination or cancellation of the life right by agreement reached with the developer if you want to move out of the scheme earlier, and again according to a process and formula dealt with in that contract.
So you can't get a bond on your life right, can you?
Correct, Mark. This is one of the main disadvantages of life rights, as you would need cash to buy into the life right scheme. But this is also one of the reasons why it is less expensive to buy life rights rather than the property itself. And of course, paying cash holds some risk, but this is precisely the reason why there is legislation aimed at protecting the retired person.
Belinda, what is the proof then of life right for the holder?
So, Mark, that will be your signed contract and the payment that you made to the developer. And the developer is also obliged, before receiving your payment, to have their title deed endorsed, signifying that the property is subject to a life right agreement. So you do not get a title deed as such, as you would with ownership, but you could and should get confirmation of the endorsing of the developer's title deed.
So, Belinda, what is the greatest risk to a life right?
The greatest risk would be if the developer who sold you the life right was unable to repay you the loan amount at the end of the contract. And hence it is critical for listeners out there to do a thorough due diligence on who it is that they're buying from, whether it be a development company or an institution, and find out how reputable they are in the life right industry, how well known, how long they have been around, etc. Look, there's no doubt that a life right is a very strong right in terms of one's occupancy at the property, and you cannot be dispossessed by, for example, a bondholder where the developer's property is bonded and the property now needs to be sold in execution of that debt, or by any other creditor for that matter. Even if the owner-developer were in trouble and the property needed to be sold, it would be sold with all the life rights firmly in place. And on a positive note, I really do want to end and say that we have seen that life right schemes have become more and more attractive and options since COVID-19 and lockdown, especially since they offer the communal living and extra facilities for retired persons and are wholly protected by legislation catering for retired persons.
Belinda Lewis, Director at STBB. Now, when it comes to all aspects of property law, it makes sense that you have an expert on your side like Belinda. Belinda, just give us your contact details again, please.
Mark, based at the Claremont office of our firm, we have 11 branches across the country, and your listeners can reach any one of us professionals, of which there are 100 approximately, at any one of our 11 branches, and our website address is stbb.co.za.